Hello, everybody, and welcome to Political/Law Bite number 340, dated February the 7th, 2022. I'm Walter, your mobile historian and blue-collar scholar. Thanks so much for tuning in today. This Political/Law Bite is entitled Social Studies 101, The Three Branches of Government / Checks and Balances. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, MA. And in addition to that, please also click on that little that little notification bell immediately to the right of the red subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. You're the best. So again, this video is entitled Social Studies 101, The Three Branches of Government / Checks and Balances. In the United States of America, both on the state and federal level, there exist three branches of government. These three independent branches of government function in their own spheres and serve to check and balance the power of the other two branches. The branches are as follows: the legislative branch, the executive branch, and the judicial branch. This video will provide a brief overview of each and how they serve to check the authority and reach of the other two. The purpose of checks and balances is to keep each branch in its proper lane, allowing none of them to dominate the others. We begin with the legislative branch of government. In the United States, at the federal and state level, there exists a legislative branch of government, all right? At the federal level, it is known as the U.S. Congress. That body is responsible for enacting federal laws, reviewing and confirming presidential appointees, impeaching and removing federal officers, passing U.S. constitutional amendments before they're sent to the states for ratification, regulating federal spending, maintaining the nation's military forces, and other duties specified or implied by the United States Constitution. On the state level, in all 50 states, state legislatures draft and enact laws, impeach and remove state officials, regulate state spending, draw state congressional and legislative districts, and perform a litany of other regulatory functions pursuant to their state constitutions accordingly. State legislatures make the vast majority of the laws which govern the American people. And like the U.S. Congress, their members are directly accountable to the voters. Within the states, and depending on the state in question, local governments may or may not have a specific power, a legislative branch, usually known as a city or county council, all right, with the power to enact local ordinances and regulations. It varies greatly from state to state. Some states don't believe in county government, all right, consolidating that power sometimes in simple cities. It varies from state to state, like I said. Thus, although, local governments have many responsibilities, the primary bulk of that comes from the state, all right, and the primary function of legislative bodies, ladies and gentlemen, is to craft and pass laws which serve to govern our society. All right, so that takes us next to the executive branch of government. Both the federal and state governments have an executive branch of government headed by a chief executive. On the federal level, this individual is known as the President of the United States. On the state level, this individual is known as the state governor. On the state level, on the federal level, the President of the United States is our nation's head of state, our chief magistrate, and our head of government. He is responsible for directing the daily operations of the United States government, all right, proposing legislation, signing executive orders, signing or vetoing bills passed by the Congress, appointing federal officials, including judges, ambassadors, heads of executive agencies, and his immediate staff, issuing pardons, directing the nation's foreign/domestic policy, ordering the U.S. military into action if necessary, and of course, a litany of other functions. The President of the United States is indirectly chosen by the American people, all right? And why do I say indirectly? Because we have, of course, what? The Electoral College, which, of course, is explained in another one of my videos, all right? The President serves a 4-year term, which is renewable only one more time, all right? In the individual states, the power of governors varies significantly from state to state. And that is an understatement, all right? But several powers related to the governor are common to virtually all the states. Besides setting the general policy and direction of the state, governors typically have the power to remit fines and issue pardons for offenses against the state. They, of course, are the commander of the state's individual militias, which, if you're not familiar with that is, it's the state's little domestic army responsible for keeping law and order should things like riots and revolts happen, all right? And they can certainly direct this force to preserve the peace and order of society in the state. You know, like I said, when civil disobediences abound. All right. Governors have the power to sign or veto the laws enacted by the state legislature. All right. Depending on the state, governors have ranging levels of power to set the state's budget, subject, of course, to the oversight of the legislature. Governors typically appoint certain executive branch officers in the state. Again, that varies greatly from state to state. They have the power to typically fill judicial vacancies, even if most judges in the state are elected by popular vote. Again, varies greatly from state to state. And many often serve as ex officio members of certain organizations. All right. State governors are directly elected by the voters of the state and are usually bound by term limitations in that office. Again, as with all this, it varies greatly from state to state. Thus, the primary function of the President of the United States and state governors is to ensure that the laws are faithfully executed and are not ignored or willfully defied. That takes us to the third and final arm of government, the judicial branch. The judicial branch of government exists at the federal level as well as all 50 states, all right, in the District of Columbia, all right? The judicial branch is vested with the authority to dispose of civil and criminal cases, controversies, and other legal issues. In doing so, they interpret and apply applicable laws, and depending on the circumstance, set legal precedents, all right, which are situations that can be followed in future circumstances having similar or analogous facts and issues. On the federal level, there is a 3-tiered court system. The district courts, the U.S. Courts of Appeals, and the Supreme Court, supplemented by several smaller limited jurisdiction courts, such as bankruptcy courts, tax courts, U.S. Court of Claims, and many others, all right? Judges on the federal level are typically appointed, almost all of them are appointed by the President of the United States and confirmed by the U.S. Senate before taking office. All Article 3 federal judges are appointed by the President and serve for life. Article 1 judges, such as bankruptcy judges, serve for a term in office, which must be renewed, all right, by either the President and then reconfirmed by the Senate, or depending on another manner in which that judge is appointed, they would have to be reappointed by whichever authority appointed them the first time, all right? It varies from Article 1 court to Article 1 court, all right? Judicial structures in the states, however, are far more varied, okay? That, too, is an understatement. In the states, all right, you do see some commonalities, however, usually being at least one court of last resort, usually known as a Supreme Court of Arizona, Supreme Court of California, or Supreme Judicial Court of Massachusetts, and a major trial court of general jurisdiction, such as a circuit court, a superior court, or a district court, depending on the state. Certain states may have only one trial court and one appellate court, all right, like West Virginia only has circuit courts and a Supreme Court of Appeals, all right? They're the only state Supreme Court with that particular name, by the way. While other states may have several layers of courts and or several different subject matter jurisdiction courts that often have overlapping jurisdiction. When I tell you each state has a judicial structure that is not replicated by any other state in its entirety, I am not exaggerating. Each and every single state and the District of Columbia has a unique judicial structure that is endemic to that locale, not completely replicated by any other place. All right. Even if the only difference is the name, that's still a difference unique to that state right there, not replicated completely 100% by any other jurisdiction in the U.S. All right. So in the states, the process of judicial selection and retention in office also varies considerably from state to state. The vast majority of states have elections for at least some of their judges, all right, whether it be contested or retention. A retention election is simply an election where you vote yes or no whether or not a judge should stay in office, all right? They don't have the ability to be challenged from outsiders, all right? A contested judicial election, of course, is when a judge can be challenged from someone off the street for their office, something I've always been very, very against, okay? Other states allow the governor to appoint all judges when vacancies occur and have the governor reappoint them to additional terms or for a life term until they reach a certain age, okay? Lastly, certain states allow for both gubernatorial appointment and the election of judges, known as the hybrid method. That's what we do here in my state of Maryland, all right? In civil cases, all right, moving to jurisdiction, one party brings a lawsuit against another, which is known as an action, in order to obtain some sort of relief, whether it be monetary damages, an injunction, various types of writs, replevin, detinue, peace orders, protective orders, so forth and so on. Criminal cases involve the government, all right, bringing a formal indictment or an information against an individual for one or more offenses against persons or property in society. Both civil and criminal cases can be decided solely by a judge or also by a jury if they meet the appropriate circumstances. An appeal to a higher court may possibly be taken by the losing party if it is argued that there was some sort of procedural irregularity or misapplication of the law in the lower court or courts. Courts thus serve as the branch of government responsible for resolving legal disputes between parties, punishing and or reprimanding individuals who have been proven to be guilty of criminal acts, and providing finality on the meaning of the law in general. So now that we have an understanding of how each branch of government functions, we now move to how each branch serves to check the power of the other two branches. So beginning with the legislative branch, both the Congress on the federal level and the legislatures on the state level have mechanisms to check both the executive and judicial branches in their respective realms. On the federal level, Congress has the ability to check the executive in the following formats. First, Congress can refuse to pass the budget proposed by the president, leading to a government shutdown due to, of course, lack of funding. This also extends to refusing to fund presidential initiatives. Second, should the Congress not approve of a foreign military action initiated by the president, they could very easily refuse to fund the war itself, resulting in the conflict's inevitable, untimely conclusion. Third, the Senate may withhold confirmation of executive nominees, such as department heads, cabinet secretaries, and judges, thus inhibiting the ability of such departments from functioning properly. Fourth, Congress may absolutely refuse to act whatsoever on the president's domestic or foreign policy agendas, leading to a very ineffective administration for said president. Fifth, Congress may override a presidential veto if at least 2/3 majority in each house votes to override the veto, and if successful, that bill becomes a law. Sixth, the Senate can reject a treaty that the president or subordinate has signed by not granting a minimum 2/3 vote approval, as mandated by the Constitution. Finally, Number 7, impeachment is arguably the most powerful congressional check against the president. A simple majority vote in the House of Representatives is all it takes to bring one or more charges against the president. Once the president is impeached by the House of Representatives, he is then tried in the U.S. Senate. And if convicted, removed from office. All right? As well as other types of political penalties assessed. Congress additionally has the power to check the judicial branch of the federal government in the following ways. Number 1, as always, the power of the purse remains supreme. And like with any entity, Congress may refuse judicial initiatives and pay raises by withholding funding. Number 2, Congress may impeach and remove members of the federal judiciary for various types of misconduct and malfeasance in office. Number 3, with respect to perceived misapplications of the law by the judiciary, Congress may override statutory decisions by the federal courts entirely by altering the language of the statute in question. Number 4, additionally, Congress may propose constitutional amendments as response to override unpopular Supreme Court decisions. Number 5, the Senate can simply refuse to confirm judicial nominees to the federal bench, thus leaving that branch short-staffed and very backlogged in its casework. Last, number 6, Congress may engage in the practice of jurisdiction stripping, thus preventing the courts from hearing certain types of cases. Okay, so that takes us to the state legislatures and their ability to check the power of the executive and judicial branches of their respective states. So state legislatures have the similar authority to check the power of governors in the following format. Number 1, like Congress on the federal level, state legislatures can refuse to pass a proposed gubernatorial budget and may often strike items from the budget altogether. Depending on the state, they may or may not be allowed to add things in their place. Number 2, state legislatures may refuse to confirm gubernatorial appointments such as judges, department heads, and cabinet secretaries. Number 3, they may refuse to fund gubernatorial objectives or act on the governor's sought legislative initiatives for the state. This is more likely to occur, of course, if the governor and the legislature are of different political parties. Number 4, state legislatures possess the ability to override gubernatorial vetoes of legislation, providing that they typically have a supermajority in both chambers to override. And last, number 5, state legislatures have the power to impeach and remove a governor from office for various types of misconduct. So, state legislatures have the power to check the judicial branch in these methods. First, state legislatures possess the power to control funding to the judicial branch and can limit or withhold said funding, thus inhibiting judiciary pay raises and other sought initiatives. Number 2, legislatures can impeach and remove state judges from misconduct in office. Sometimes this process includes the governor, depending on the state. Number 3, the legislature may override judicial decisions based on a state statutory provision by simply amending the language of the statute. All right. Number 4, for judicial decisions based upon the state constitution, the legislature would have to pass a constitutional bill seeking to amend the state constitution for the purpose of overriding that judicial decision. Number 5, the state legislature can refuse to confirm judicial appointments by the governor, thus inhibiting the courts from functioning at the maximum of their abilities. Lastly, number 6, state legislatures may engage in jurisdiction stripping from the judiciary, thus preventing the courts from hearing certain types of cases. So that takes us next to the executive branch of government and their ability to check the legislative and judicial branches. On the federal level, the president has the ability to check the power of Congress in the following ways. First, the president may veto bills passed by Congress, either by standard method or via a pocket veto, refusing to sign it within a certain amount of days before session of Congress has ended, and thus the bill dies a natural death. Theoretically, he put it in his pocket and let it die on its own. All right? Second, the executive may stall in signing a budget bill, funding the government, initiating a shutdown. Okay? And finally, the president may, according to the Constitution, call Congress into special session or either house individually. And he has the power under the Constitution to adjourn Congress at his disposal when they cannot agree on a date to adjourn. As of the time of this recording, the last mentioned power has never occurred. The President of the United States has the power to check the power of the judicial branch in the following methods. First, by having the ability to appoint all Article 3 federal judges, the President can inhibit the power of the courts for whatever reason by not appointing judges to staff them, increasing their backlog of work, denying justice to thousands. Additionally, with the power to grant pardons to those charged with federal crimes, or even possibly going to be charged with federal crimes, this is a check on the power of the courts to impose sentences, all right? That takes us to the power of state governors to check the ability of the legislative and judicial branches of their respective states. Governors have the ability to check the power of the legislative branch in the following formats. Like the president with Congress, they too can refuse to sign a passed budget from the legislature, leading toward a state government shutdown. Next, governors can veto bills passed by the state legislature and delay signing bills into law. Governors typically also have the power to call the state legislature into special session should the need require it. The governor may check the power of the state's judiciary in the following formats. First, even in states where judges are elected, midterm vacancies tend to require gubernatorial appointments until the time of the next election. The governor may stall or refuse to appoint someone to a judicial vacancy, thereby inhibiting the power of the courts to function properly. Additionally, a governor may grant a pardon to someone convicted of a state crime, thereby checking the power of the courts to impose punishments. So, now we move to the judicial branch and its ability to check the power of the legislative and the legislative and executive branches of government. Comparatively speaking, the courts have the least amount of power to check the other two branches. To quote Alexander Hamilton in Federalist 78 from the Federalist Papers, okay? Hamilton said that the courts, okay, are indeed the weakest branch of government, that they indeed possessed neither force nor will, but merely judgment, all right? And that's true. The courts don't have the power of the purse, like the legislature, and they don't have the power of the sword, of course, which is the militia on the state level or the army on the federal level, all right? Like the president or the governor does, all right? So courts merely have judgment, and the way to enforce their judgments is by having the political branches go along with them and enforce them, all right? So, on the federal level, you know, from the constitutional standpoint, the courts certainly nowhere near as much power as Congress or the president. So on the federal level, the courts have the power to check the executive by declaring the actions of the president to be unconstitutional and or issuing injunctions against an executive action. By virtue of the Supremacy Clause of the Constitution, federal courts can also declare state gubernatorial actions unconstitutional or by issuing injunctive relief if those actions violated federal law or the Constitution. Similarly, federal courts can check the power of Congress by declaring acts of that body to be unconstitutional or by issuing injunctive relief. Federal courts also possess the power to declare state legislative actions unconstitutional or issuing injunctive relief if they violate federal law or the Constitution. To the state level, state courts have similar powers as their federal counterparts to hold the legislature and governor in check. First, state courts absolutely have the power to declare acts of the state legislature unconstitutional and by issuing injunctive relief. Second, courts also have the power to declare the actions of the governor to be unconstitutional or by issuing injunctive relief, thus checking the ability of the executive in a particular arena, all right? So the summation of it all is that each branch has its own individual realm of authority and the power to check the other two branches. The power of each branch to check the other two branches will vary greatly, all right, depending on what is in question and what's on the table here. So we learned that both at the federal and state level, there are three branches of government, folks: the legislative, the executive, and the judicial. All right. With it, all the branches have the power in their own respective ways to check the power of the others. It is known as checks and balances. Okay. The purpose of checks and balances, again, is to ensure that all the branches stay in their own lane and none of them are able to entirely dominate the government. So that concludes Social Studies 101, the three branches of government / checks and balances. If you have any questions or controversies, please leave them down below and I will be most happy to answer them. If you like this video, learned a thing or two from it, please drop me a like. That matters a whole lot. And if you've not subscribed to my YouTube channel at this point, please do so now. You know, your support means more than you'll ever realize. Juarez Lee Shelton, M.A. Thank you so much for listening. It brings me great pleasure to teach, you know, individuals such as yourself. You know, if you had no idea what I was talking about before I did this video on this subject of separation of powers and checks and balances, I hope you gained something from this video. So I conclude with the timeless words of one of my teaching role models, Mr. George Feeney. Believe in yourself, dream, try, and do good. And I will talk to you at the next video. Cheers and peace.